Yeah, you can just bring your cup, just open it and bring your time in. Either five out there.
There's a few. Mine included.
Oh, bring them in.
It's audio makes work first.
Ah,
For some reason, I clicked and plugged them.
mhm.
And they are giving me a hard time.
Okay, sorry. Whenever I put mine in, it was like long stuff. Did you want me to lock the door or? just wait?
Yes.
Okay, let me go. Mhm. Mm. 7. Mhm. No. I think this. I don't know if I don't think it's considered. I haven't done it. It's everywhere.
Mhm.
Okay, Jeff.
All righty. Thank you very much. They're beautiful. I think it is.
It's like under, you touch it. Yeah, it was cool. Over here. There it is. That's, your cream is real. Real. Now you're for sure, you're for real gonna stay. Looking, I'm leaving. Just kidding. Okay, do you want to update? I guess I can go with that for now. Um, yeah, this is switching somewhat. This one. It's already done. And then I'll be right there. And then this one. We want to update this one. Okay, so as well. I already want to put the document in the.
Okay.
This will be. Yes, sir.
And normal?
She's the package. Matthew. Yeah. Give me 1 second. There's. You're gonna wait for when Norma gets here.
more pushing. So he knows the street and then he was.
Was it for the deputy? Okay. Yeah. Mhm. I think she has the docket with her. Do you have David is for the notes?
Yes.
Can I wanna? He called IT.
All right, can somebody call IT, please?
Yes, ma'am. He's the guy who- he's the guy with the injury.
Published.
Yeah, this is not the one with the- so then our court reporter is having issues with the stuff. Can you go to someone down to help her out? Oh,
That's where we sit on this repetitive.
Mr. Pettis?
All right.
And then I do need to talk to the judge about something that's not on the docket. I'm just gonna get you start trial.
So, Mr. Hicks, is your client on bond or no?
No, Judge, he's in custody.
All right, and Mr. Castagnon, is your client on bond or no?
He's in custody, Judge.
All right, they're bringing them out. As soon as they bring them out, we'll take your matters up.
Thank you,
Thank you,
Judge.
Judge.
You're welcome.
Thank you.
All right, Christy Riojas. Who is here on Matthew Stephen Martinez?
I have judge. I'm here for the.
He's in custody?
No, he's right here.
All right, come forward.
We're asking the court, the first sitting, we're
You're on this side.
we're asking the court for a reset.
So where are we on discovery?
I just started into the case, Your Honor.
All right, all
I'll find out everything too later on today or tomorrow.
right, State, have you uploaded all discovery, you think?
The state believes so, yes.
And can you make sure that there are no body cameras or dash cams that need to be uploaded?
It's better.
All right,
I
Ms.
have
Ferguson.
the information, they have some videos there already. I don't know if it's all of them, but they have videos.
All right. Norm, I need a 30-day reset for discovery on Matthew Martinez.
August 28th.
All right, you're gonna come back on August 28th.
Thank you,
Once you
Judge.
sign the reset form, you're excused.
Thank you, Judge. Maybe excuse after that.
Yes.
Thank you.
All right, just have a seat, sir.
Notice,
Or have it's not in
and that's, it's not in there.
the, like, you want me to drop the little one?
If you can, so we can update it.
No problem.
Uh-huh.
Is it, can I get checked in the light?
They didn't give them to you, I will do it right now, give me 1 second.
Yeah, I have a friend in the light.
I'll check. Oh, it's right here.
What is this for me?
Yes, sir. Yeah.
All right.
That's Orlando's case, Judge.
Okay.
There you go. You want it? And then I'll get you the. Oh, I can give you this one. This one's already written on. He's going to do it, right? Bottom. Or the opposite.
Yes. Yes, to keep them calm. All right, thank you.
Yes.
Maybe it's civil for.
Do I go to the third? Already have problem with the elements.
Oh, yeah, notice, you should be, there should be some in the back. Yes, go ahead.
He says he wants to pay his protocol. You heard. But they're not.
Thank you, no, they're right here.
I've got a bond issue in my 13 and my phone. Sometimes you from the market. It's still frustrating.
And Orlando's supposed to be on Green Shore, so.
All right, who is here on Emmanuel Moses Perez?
Judge, I'm here. Mr. Pettis is here.
All right, why was he late for court today?
He was in court 12 first.
Okay.
In fact, we still have to go back over this.
So court is at 9, okay?
Yes, but I had been checking that for 12, the next thing over here.
So I always tell people, I never try to pull rank, but this is a felony court. Okay? All right, so there is a motion requesting the reinstatement of the bond. Why do I have this?
That should not have been.
That's probably mine, Judge. That's David Moses Escobedo.
Ah, okay. Thank you. Just give us a second and we'll take you up, Mr. Castignon. So on Emmanuel Moses Perez, let me look this up. Why does it have him listed as bond fugitive?
There was a bond increase on the misdemeanor.
Mhm.
And then so when he came in here, he was picked up on that.
Okay,
And then I went down to 12 and was able to straighten that out. So that's been recalled.
all right. Let me just make sure it's in the Odyssey, because if it's not in Odyssey,
Oh,
he'll probably get picked up today. All right, so there's nothing here in the system.
Yes, he's been picked up one today, Judge. We'd like to avoid it being twice.
Okay, all right, so where are we on the discovery matters?
We are continuing to get things in through the civil case. But I've discussed all that with the state. The state's giving me everything they have. To the extent that I get things that are relevant, I'm gonna go ahead and hand it over to them when I get it.
Mhm. All right, so, state, were you able to tender an offer?
Yes.
Okay, so Ms. Ferguson, on this case, I need a 30-day reset for a plea deadline date.
August 23.
All right, August 28th. Once you sign the reset form, you're excused. And if y'all can make sure I have an acknowledgement of discovery before you leave.
For sure.
All right, and thank you for dressing appropriately for court.
And me?
Oh, yeah, that's a given.
There's Rick and I have been discussing an off-pocket bond matter.
Just let me take care of these
I know
cases.
you're busy or
Yes,
helping out or anything.
Okay.
helping out or whatever.
all right. I'll take care of
Yeah.
these and then I can take that up.
Just, I have a credit card here, which should not be.
Oh, just, if you're ready with all the paperwork, you can just put it here and I'll take care of it.
Okay.
All right, thank you. Esther La Fuente. And to the people who are on Zoom, I'm just taking up other matters first because there's an issue with the court reporter's equipment. And then I will take you all up as soon as that's addressed. All right, on this case, let me find her on the docket. All right, where are we on discovery?
Your Honor, we're good on discovery. The state relayed an offer today. I've conveyed that to the client. We do have some work to do on our end on witnesses, but that's where we're at, yeah.
All right, how old are you?
25.
All right, Ms. Ferguson, I need a 30-day reset for a plea deadline date.
August 28th, Judge.
All right, August 28th.
Thank you, Your Honor.
Once you sign the reset form, you're excused, okay?
Thank you, Your Honor.
All right, and thank you for dressing appropriately for court.
Always, this has to be plugged in for tomorrow, so there's that one.
And state on Esther De La Fuente, if you can do acknowledgement of discovery for me, please.
I had undone it. Yes. Yes.
Carlos Perez. Okay, who's your attorney? I'm sorry, who? Roberto Ambrosino. All right, just give us a moment.
For some reason, they're not charging by. That's not from this, it's okay. Yes, I'm not doing it.
All right, Orlando Castellon
Yes, Judge.
on David Escobedo. What is the issue with the bond?
So I spoke with the bond company and I think the clerk had said that because the bond had already been closed out, that they couldn't restore it. So I was going to ask that you just set the bond amount at the previous amount. And the bond company said they would be posting a new paperwork for the bond.
All right, state any objection to the previous bond on Mr. Escobedo? Just one moment. I'm sorry, it's taking a little bit while for Odyssey to open documents for me.
Did not see him on our doc.
Yeah, it said bond increase, it was at 20,000, Judge. That was on February 10th of 2025.
There was subsequently though a motion to reinstate bond, which happened. And so I believe the previous bond was actually still 10,000.
I'm looking for it here. Just one moment.
Yes, Judge.
If not, I can print it out, Judge, if you want.
Yes.
Yeah. And yeah, I think I tried to, because I thought, you know what, I'm not ever looking at an external recorder to it. So I did this. And I just put it in here. That's what it cut off. Oh, I know, it's. I'm not, you know.
All right, the previous bond was $10,000.
And you Steve asked in reference to what we thought was an original increase to 20, what the reason, if it wasn't increased.
It was, I think it was increased by another judge, not by me. I didn't increase it to
It was
20,000.
increased, I think, under Nahara, Judge Nahara. He had gotten to compliance with ignition interlock, and the judge reinstated the.
I think the state would recommend doubling the bond if the issue would have been the ignition interlock.
Something.
That's not why this bond was.
Well, what-
That's not why there was a warrant issued here previously.
So let me ask you this. So I see that the original bond was $10,000. And then there was a bond increase on February 10th, 2025. And that's the bond that was made by the defendant, correct?
I believe it was reinstated
Yeah, these are all.
because he became in compliance with his ignition interlock. I think he had not had it installed.
All right, the only thing is I don't see that on the system, council. I just see his bond was at $10,000 originally. And then it was increased to 20,000. So Norma, can you check to see if he made the bond of 20,000 or 10,000?
Yes, ma'am.
And so we'll find out which one it's supposed to be, council.
Okay, Judge.
I can still see your.
All right, while they're looking for that, Mr. Roberto Ambrosino,
Yes, Judge, I'm here.
you're here for Carlos Perez.
Yes, Your Honor.
All right, Carlos Perez, if you come up, please.
Okay.
All right. So on this case, the offer was tendered, correct?
Yes.
Today, yes. Counsel?
Yes, Your Honor. I have conveyed it to my client. He is not willing to accept it at this time.
All right, Ms. Ferguson,
Yes, ma'am.
set this for a jury trial. It should be short. It's a fraudulent possession of identifying information. So with jury selection, it should probably take a day.
Yes, sir.
Do you want a jury trial or a bench trial?
What's the difference?
Jury trial, Your Honor.
Great.
All right, a bench trial is where evidence is presented to me and I make a decision on whether you're guilty or not guilty. What I can tell you is if the state proves this case beyond a reasonable doubt, I'm going to find you guilty. If they don't, I'm going to find you not guilty. A jury trial is where 12 citizens will sit and they will listen to the evidence and they will make a decision. So your attorney is saying that you wish to have a jury trial. Is that correct, sir? Mr. Ambrosino, is that correct?
Yes, Your Honor.
All right, Norma, I need a quick turnaround for a jury trial on this, please.
Is September 23rd okay, Judge, or you want something? sooner?
Yes, September 23rd will be your jury trial date.
Thank you, Judge.
Once you sign the reset form, you are excused.
Thank you, Judge.
Your plea deadline date has expired. The court will not accept any plea bargain agreements in this case without good cause. Otherwise, you have to plea open to the court. Do you understand?
Yes.
All right. Well, I mean, is there something you don't understand?
Well, yes, I do.
All right, if you don't understand, let me know.
Thank you.
All right, just remain and they'll give you a reset form to sign.
Mr. Pettis, come here and grab.
Thank you, Judge.
You're welcome.
And sign where it says
Thank you,
defendant.
Judge. May I be excused?
Yes.
Thank you.
Grab a flower too. This is defendant. Yeah.
Thank you. Yeah. Yeah. Judge, I don't know. Judge, do you want me to tell? can you
Just give me a
tell her-
moment. Give me 10 minutes. That's all I'm asking. I'm just waiting for the court reporter to see if her microphones work.
If they don't, we're gonna go. I just rebooted it just one last time. Just to try.
Okay, no problem.
I will fix it.
All right, so do we have an update on Mr. Castellan's client, Escobedo? No. I mean, they're supposed to tell me what the bond amount was.
Oh, Judge, it looks like he did make the bond at 10.
All right. So state,
Yes.
I believe that Judge Nahara put the bond at 20,000, but then once he obtained the ignition interlock or whatever he needed, the judge put the bond back at 10,000.
The state would still be of the mindset that bond is privilege, and if there were something that resulted in a revocation, we would recommend doubling. State won't decide if it's put at 10, but we would recommend double.
Okay. All right, so Mr. Castagnon,
Yes, Judge, my understanding is the court was intending to reinstate this bond.
no,
And-
I'm not asking you for further argument.
Okay,
I know the reason why his bond, the reason he was taken in custody. The defense sent a motion to reinstate bond to the state. And it was filed with the court. The court has reviewed that. The court is understanding that there will be no more disruptions from your client. The court will set the bond at $10,000. There's to be ignition interlock on any vehicle the defendant has access to. And there's going to be 30 sober meetings in 30 days. And counsel, where are you? Do you have all your discovery or no?
I have received discovery. I received blood discovery. I need to get that reviewed. And we were given an offer today. I relayed that to my client. And we don't have we have not really had an opportunity to discuss the offer.
All right, Ms. Ferguson, I need a plea deadline date in 3 weeks.
Yes, ma'am. It is August 19th.
All right, August 19th.
Okay, Judge. Get
Set
on my
form,
calendar.
please. Thank you.
Yes,
May I be excused, Judge?
Yes.
Thank you so much.
All right, Mr. Hicks, who do you have? You're on mute.
Sorry about that, Judge. I have Mr. Rodriguez. Elijah Rodriguez.
Yes.
I'm ready, Judge, whenever you are.
Okay. Could I see the file? What is the first name, please?
Elijah.
Could I see the file on Elijah Rodriguez, please? That is actually
Okay.
Thank you. And he's already been sworn in?
Yes, Judge.
All right, the court is calling 2025 CR 007538 State versus Elijah Rodriguez. Can I have parties announce?
Andrew K. Hicks for the defense.
And are you Mr. Rodriguez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review that with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. All right, off the record for a moment. Do y'all have the true bill of indictment? And is there an application in this case?
There's not.
All right,
No, Your
Mr.
Honor.
Rodriguez, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Oh, I found it. It's for the papers.
Okay.
Your Honor, in regards to the true bill of indictment, the state does have an oral amendment.
Okay, just one moment.
Yes, Judge.
You reviewed that with your attorney.
Yes, ma'am.
Defense, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, but with an oral amendment.
Yes.
That has been spoken to defense. When you look at the indictment, at the bottom, it says, and this was to enhance to get jurisdiction in cause number 2023 CR 009809. That should read 2024 CR 009809.
Any objections to that change?
No objections, Judge. It looks like it was just a clerical error. I did confirm it with my client.
All right, and Mr. Rodriguez, you understand that that's a substantive change to the indictment?
Yes, ma'am.
And knowing that, do you still wish to proceed with that change?
Yes, ma'am.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with theft of property 2,500 or more. I'm sorry, less than 2,500 with 2 or more previous convictions. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? You need to say yes or no.
Yes.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe so, yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 8 months in the state jail facility. The state will take in consideration 2025 CC 005803. There's to be restitution, if any, to Home Depot and no contact with Home Depot. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offered State's Exhibit 1 and all attachments at the center.
No objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We just ask that the court follow the plea bargain agreement, Judge.
All right. So, Mr. Rodriguez, why do you keep doing this? What's going on in your life?
I'm gonna be very honest, Khalid. I'll have to be sent to a rehab because I do have a low drug addiction.
All right, and what drug might this be?
Climax,
I'm sorry, what?
synthetic marijuana.
Okay. All right. So here's the thing. I believe, and I could be wrong, but I believe your attorneys have reached this agreement because of the number of priors you have. State, I don't know if you all want to reconsider the plea bargain agreement. The defendant is saying that he wants rehab. But I don't know, I haven't looked into your complete criminal history because I'm being objective and keeping an open mind.
Your Honor, history was part of the state's offer and recommendations.
Okay.
And like mine have gotten us to this point.
Okay. All right, this is what I'm going to do. I'm going to follow the agreement. Going to sentence you to 8 months in the state jail facility. Give you credit for any time served. There's to be restitution, if any. And no contact with Home Depot. I'm going to order the therapeutic community for you. I can't force them to place you in the therapeutic community, but they're going to see in the judgment that I'm requesting that for you. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. If you're serious about wanting help for your drug problem, when you're released from the state jail facility, if I'm still here, you come back in here, I will pick up the phone for you and I will find a place for you that will take you inpatient, okay?
Yes, ma'am.
But it's going to be completely up to you. All right?
Yes, ma'am. Thank you.
All right, you're welcome. Good luck to you, okay?
Thank you. God bless you.
Oh, thank you. God bless you too.
Thank you, Your Honor. May I be excused?
Yes. Alfredo Compost. Is this a plea?
Yes, Your Honor.
All right, can I have a file stamp for a plea, please? Court is calling 2025 CR 0022720 State versus Alfredo Compost. Could I have parties announced?
In the state of Texas.
Renee Munoz on behalf of Mr. Compost.
All right. Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Is there an application?
No, Your Honor.
All right. Mr. Compost, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Your Honor, say we're proceeding. Additionally, Your Honor, say we'll waive the repeat offender enhancement.
Also no objection.
Okay. All right, did you review the document entitled court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right, in count 2, you're charged with assault family household member with a previous conviction. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
in my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes,
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. State is proceeding on count 2. There's an affirmative finding of family violence. There's to be no contact with the complainant. Did you understand that to be the plea?
yes,
Defense, is that the plea?
yes, Judge.
State, is that the plea?
It is, Your Honor. I did mention when you get to the stipulation.
Right. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
And you're not allowed to be designated as a primary custodial parent?
Yes, sir.
Right. Knowing that, do you still wish to continue with this plea?
Yes,
Right. Did you review the waiver of appeal paragraph with your attorney?
yes, sir.
Did you understand it and sign it in both places? Did you understand it and sign it
Yes,
in both places?
yes,
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
yes, sir.
Counsel, are there any such motions?
No, Judge.
Then to the offenses charge, how do you plea in count 2? Guilty, not guilty, or no contest? State, any evidence?
This time state the evidence, states exhibit 1 with all attachments. No objection.
Right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're asking the court follow the negotiated plea bargain agreement, Your Honor.
All right, so what is wrong with you? This is a person, for whatever reason, decided to pick you up from custody when maybe she should just let you stand there, for whatever, and let you just stay there. She takes it upon herself, and I'm sure she paid your bond, and she picks you up and brings you back home, and then you beat her up. What's your issue? Yeah, I mean, you do, because somebody do you love her, or do you claim to love her?
No.
No, you don't, because that's not the way you treat people you love. She took it, probably money from her children, to pay to bond you out, and then, all right, let me tell you what's in the police report, and you tell me what's incorrect about this. I asked victim what happened. Victim stated the following events occurred. Since Wednesday, she went to pick you up from the jail. She stated they were good, no problems. Later that day is when the defendant began to strike and choke the victim. So this is where we are.
Or I don't know if, I think he just got a little bit tangled up. I don't know if he bonded out or if he was just released at that point, and then she picked him up instead of the bond. I think that's where he was a little confused.
I was just confused because I was released from my stuff, not from the county jail.
Oh, okay, so there was no bond posted. Okay, that's what I think he.
So here's my question. Is the reason for this offer because the complainant does not want to participate and has filed an affidavit of non-prosecution? All right. So she's filed an affidavit of non-prosecution, even though I'm looking at the photos, she has a black eye, she has bruises on her arms, and she took time out of her busy schedule to come pick you up from wherever you're incarcerated. So for some reason, she's attached herself to you, but I'm going to try to break that cycle today. So I'm going to sentence you to 3 years in prison. There'll be credit for any time served. There's a $1,500 fine. Time and money is not running concurrently. There's an affirmative finding of family violence. There's to be no contact with Ana Maria Hermio, AKA Ana Maria Gonzalez, and you're not allowed to reside in any residence with minors. Do you understand? Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed this plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. We can go off the record. Here's the thing. Don't get involved in any other relationship. Don't contact her. If you love her, the best thing you can do for her is not contact her, because you're not any good for her. And until you figure out why you feel the need to put your hands on people in anger, you should not be in anybody's relationship. Here's my advice to you. Get an orchid. I always tell people that, and this is why I tell people to get an orchid. An orchid takes a lot of patience. When you get it from the store, it's beautiful. They all have them all with the flowers bloomed on it. They will give you directions. Those directions don't work. I learned you're not supposed to put ice cubes in them. But if you can let the blooms fall off of that orchid and keep that same orchid and get it to rebloom, you may be ready for a relationship, because with orchids, you have to learn patience. You understand? All right, good luck to you.
Thank you.
You're welcome.
Just have a seat up there.
Who's here? Isidro Garcia?
That was Christopher Simpkins, Judge. He had talked to you earlier.
Yeah, he's supposed to appear by Zoom. So what does that mean?
I thought he said he was coming to the house. He was, coming over to the courthouse. He said he was gonna be a little late.
All right, so
He's in the box, Judge.
we can have him, if you could hold him just for a little bit. All right, and then who's the other person in the box? With the,
Gomez?
what page is he on?
Desmond?
All right, what is happening with Mr. Gomez?
I'm sorry, Judge, we were taking a look at the plea paper one more
Okay.
time to discuss an issue, but we're ready.
And then the other person, you can put a hold on them. Court is calling 2025 CR 007217 State versus Desmond Gomez. Can our parties announce?
Luck for the state of Texas, Your Honor.
Christian Vega for the defense.
And are you Mr. Gomez? Counsel, have you received all discovery? Did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Gomez, did you review the application for community supervision or deferred adjudication with your attorney? Did you understand it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor. However, the paperwork before the court, because there will be a plea on all 3 counts. There's paperwork specifically for the attempted taking weapons state jail, and then paperwork for the 2 third degrees. They are from the same cause number, but because they were different levels, we are proceeding as charged, but that is to make sense of the paperwork before you.
Okay.
in the way it was indicted, count 1 and count 3 were harassment, count 2 was attempted, so I hope it makes sense.
Oh, no. Let me see here. All right, thank you. All right, so Mr. Gomez, in each of the cause numbers, did you review the court admonishments and defendants' waivers and affidavit of admonitions?
Yes, sure.
All right, in counts 1 and counts 3, you're charged with harassment of a public servant. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. And in count 2, you're charged with attempting to take a weapon from an officer as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Do you understand?
Yes, Your Honor.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea
Yes,
in
Your
this case?
Honor. Yes, Your Honor.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? And counts 1 and 3, the court could sentence you up to 10 years in prison and up to $10,000 fine. And count 2, the court could sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Gomez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain pages with your attorney? Did you understand them?
Yes, Your Honor.
And count 2, in each count, the state is recommending deferred adjudication. The counts will run together. There's to be taken in consideration 2025 PF 13273. There's to be restitution, if any, and no contact with the complaining witness. TAP evaluation, follow recommendation, anger management, and MRT. Did you understand that to be the plea?
Yes, Your Honor.
Defense is at the plea?
Yes, Your Honor.
State is at the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney in each of these counts? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? Just one second. I'm reading something else about this. All right, did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, in count 2, the state is asking that your length of community supervision be 5 years. In counts 1 and 3, they're asking that your length of community supervision be for 7 years. There's 200 hours of community service restitution and no contact with the complainant. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then in count 1, how do you plea?
Guilty. Oh, no contest, Your Honor.
Count 2, how do you plea?
No contest, Your Honor.
Count 3, how do you plea?
No contest, Your Honor.
State any evidence?
State offers State's Exhibit 1 and all attachments in both of the plea paperwork which have the same cause number.
All right.
No objections.
All right, did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty of counts 1, 2, and 3. The court will defer finding of guilt as you apply for deferred adjudication. And actually, counsel, I'm sorry, could I have the trial court certification back?
Yes, Judge.
All right, so what I'm going to do, based upon what I'm reading in the report, yes. Oh, okay, I thought you were saying something. I am going to set this for a TAP evaluation and a mental health evaluation. Is anyone requesting a PSI? I really don't need the PSI. I need the TAP evaluation done and I need the MIC evaluation.
That's fine, Judge. And we had discussed that, but we didn't make it part of the agreement, the
Okay.
MIC.
All right, Miss Norma? Yes. It's just for a MIC evaluation and a TAP evaluation. Is there any way to expedite that, Vashon? You're shaking your head, no?
Okay.
All right, so we're gonna come back on September 16th.
Okay, Judge.
All right, and I know that's a long time, but that's the earliest we can get you in. And it's really better that this be done as opposed to me just sending you out into the world, not knowing what's going on with you, okay?
Okay.
All right, thank you.
Thank you.
You're welcome.
Thank you, Your Honor.
Oh, you're welcome.
Have a seat, Sheriff.
Judge, if I file a bond motion, I can get it set off docket.
Sure,
Okay, thank you, Judge.
you're welcome. All right, let's take the inmates back. We'll do Mr. Reitmeyer.
I'm looking at this stuff. Clerk is just gonna swear in the defendant for today's trial.
Okay, thank you.
Hold on, please, have my position. Okay. And they want to think of it.
This is yours. Yeah, but, what are the conditions of your? Yeah, go miss.
Judge, may I approach?
Yes.
Lamar Simmons, I have
Yes.
requested to pull the file. Mr. Simmons didn't know he had court today. He's present now.
Okay,
I-
all right, just have them. Oh, Lamar Simmons.
And Your Honor, we had a pre-indictment court setting
Mm-hmm.
in August in about 2 weeks.
Mhm.
And that was canceled because of the indictment. We
Okay.
had a sudden setting.
Mm-hmm.
His bond company didn't notify him to be here.
Mhm.
I called A Action. They got him here.
All
That's why he wasn't here at 9 o'clock.
All right, thank you. All right, Ms. Ferguson,
Yes, sir.
on this case, if you'll set it for discovery, please.
Yes, sir. You want 30 days?
Yes.
I can do August 28th.
All right, August 28th.
Thank you, Judge.
And state if you'll be prepared at that time to tender an offer.
Yes, Judge. And Your Honor, I know that I had reviewed some videos. I need to double check if, I know that we have a discovery setting, but I may need to get with the state about one specific video, verify whether we have it or not.
Okay. All right, thank you. Thank you for getting here. Once you sign the reset form, you're excused.
Thank you,
You're welcome. And what page is Desmond Gomez on?
Page 5.
All right, thank you. Yes.
Approach me. I've discussed this with the state with Rick. Mr. Hernandez was indicted Thursday.
Mhm.
The case had been dismissed by a 3201 pre-indictment on Tuesday.
Mhm.
So he's having to repost a bond, and I'd contacted the state, couldn't get any response. The case has been around for over a year.
Mhm.
He had been placed on GPS last August by agreement,
Mhm.
just so we could show that he was staying in compliance with some
Mhm.
contact orders. And so after the re-indictment, the bond was upped, which we don't have any issue with the bond amount, we can handle that. But now there's a GPS, a full GPS condition put right back on. And because he's got a bond out with GPS condition, that's gonna hold him up there for about 2 to 3 days. And so what I'm asking the court to do is, in light of the fact that he had been on GPS for almost a year without any violations, remove GPS as a condition. Or at least remove it for 72 hours and downgrade him back to tracking where he was before. Just something that will allow me to get him out quickly.
Okay. Let me pull this up. In just one moment.
state.
John Brightmeyer, Steve Brown.
All right, and we have an interpreter here.
Yes, Your Honor. Jacqueline Payan, Spanish interpreter.
All right, please raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English and Spanish into English, so help you God?
Yes.
All right, thank you. You may be seated. All right, let's bring the jurors in.
While they're doing that, I think they just have one brief motion that both of them tonight. All right, just a motion. First row. All right, for the jury. First row, they have numbers on their chairs. All right, thank you. Number 8, second row on top, the chairs have a number. Just follow them. Have a seat and we'll talk about that later. Okay. Number 15, 16, 15 is on the bench. Wait here. Next row. Ready? Ready? Giving you your numbers.
All right, everyone, please be seated. All right, ladies and gentlemen, good afternoon. All right, that's a slow response. I have to respond a little bit better. Good afternoon, everyone. All right, I want to let you all know I appreciate your patience, but while you all were standing in the hallway, you know, we have other cases that are on our docket. This isn't the only case. So your standing in the hallway is not the state's fault or the defense fault. It's just that we had other matters. We usually have more than one case that's set on the docket. Usually we have about 60 cases that are on the docket. So that is why. So thank you for your patience in advance. You are on the 4th floor in the 187th District Court. I'm Judge Boyd. What floor are you on?
4th floor.
What's the court number?
167.
What's the judge's last name at least? Now, you probably say, lady, we know. We've been standing outside looking at your door. When are you going to let us in? The reason why I ask that question is because sometimes we may end up taking breaks. And when we do, everyone has to leave the courtroom. And believe it or not, we've had some jurors who end up going missing and the deputy finds them and they're trying to get on another jury. Or they'll say, I looked up and everybody was gone. I didn't know where to go. So if you ever get lost, if we have to take a break, if you remember 187, they'll be able to direct you because this court is the 187th court that was created in Texas. That is why it's 187. So when you see the 399th court or some other court number, You just know that that's when it was created. That's its court's number. The other thing, if you remember the last name Boyd, I'm the only Boyd in Bear County at this courthouse, so they'll be able to direct you where you need to go. To my left is the court reporter. Please keep your voice at the tone that I have it at, because that will make it easier for her. She has to take down everything that everyone is saying. And believe it or not, sometimes people speak low, sometimes people speak fast, but she has to take it every thing that you say down. Also, let's just speak one person at a time. So in the back row, are you able to hear me?
Yes.
All right, so if you'll keep your voice at this level and at this pace when you're answering questions, it'll make it easy for the court reporter. I'm going to let the parties introduce themselves to you for the state.
Hi, my name is Ashley Jones.
I'm Rick Pena.
For the defense.
Howdy, my name's John Reitmeyer.
I'm Christine Brown.
And your client?
Sorry, this is my client, Angela Suspedes Rhonda.
All right. And behind defense counsel, we have an interpreter. Here's the thing, people. I love languages. I think languages are so beautiful. When I was in school, in undergrad, also in grad school, and then in law school, people could speak so many different languages. Usually the people who are from the Middle East, they usually speak no less than 6 languages. I thought I was going to be in Paris. I'm originally from Louisiana. So when I had to take a language, hey, you should know what I took. I took French, even though my friend was saying, Stephanie, take Spanish with me. And I said, no, because I'm never going to need Spanish. And now here I am in Texas trying to learn Spanish. So I'm working on rolling my R's. People usually, Rafael, people usually realize I'm not from here. My accent always comes out when I have to say all and soul. So sometimes we'll have people who come to our court. They've been accused of offenses and they feel better speaking in their native language, the language that they grew up with. Sometimes I will have people who went to school and they spoke Spanish, or they went to school and they spoke Italian. Doesn't matter how long they've been in the United States. They will say, you know what, this is serious, or this is a legal matter. I really want somebody to speak to me in my first language, because then I know that I 100% understand. So today, Mr. Cespedes is using an interpreter. So she's interpreting everything that I'm saying, and she will be interpreting everything that you're saying. Does everyone understand?
Yes.
So is there anybody here who's going to hold it against him because he is using an interpreter?
No.
All right. Now, the other thing I want to talk to you about is the cards that you have. Those are very important cards. If you want to answer a question, just raise those cards. I will call you by the number, or either party will call you by your number. And then once they speak to you, then you can start talking. Does everyone understand?
Yeah.
Now, I'm going to ask you to do something for me and something for the court reporter, Cindy. So far, no jury has been able to do that. I'm going to tell you what I tell them, but I have faith in this group that you can follow this instruction. So everyone raise your card. When I tell you to lower your card, please lower your card. So jurors 1 through 21, lower your card. All right, this is the part that I need your help on, that no jury has been able to do, but I have faith in you. If you have your card still up, when somebody addresses you, or you want to ask a question, or you're answering a question, if you can, I'm going to need you to stand, because that will be easier for the court reporter to hear. Does everyone understand?
Yes.
Is this going to be the jury that is able to follow that instruction?
Yes.
All right, y'all don't sound very comfortable. But okay. All right, I have faith. Now, you can lower your card. Now, in this case, the charge is aggravated kidnapping. I'm going to come back and talk to you about that charge in a little bit. But neither the state nor the defense can tell you what they think the facts are in this case. The only time you're going to get to hear what people think the facts are in this case is if you're selected to be on the jury. Does everyone understand?
Yes.
So when either party is speaking to you, don't be like Mrs. Kravitz from Bewitched, throwing in the hypotheticals and saying, oh, this is what this case is about. You will not know what anyone thinks this case is about unless you're on the jury. Does everyone understand?
Yes.
So everybody is going to be speaking to you in hypotheticals. Every time they ask you a question, it's a hypothetical. It's not about this specific case. Now, I want to talk to you about the indictment. Mr. Cepedas is here under indictment. What does that mean? It is just a piece of paper. It's a document to let somebody know this is what you've been accused of. Do you want a jury trial? This is the courtroom where you need to appear for the jury trial. Does everyone understand?
Yes.
So let's practice raising our cards. How many people here have had a traffic ticket? Okay, so this is what I will tell you about this group of jurors I have before me. This has been the group of the worst drivers that we've had so far. That's okay. That's okay. You can lower your card. No, I was shocked. Maybe about 2 people didn't raise their card. Usually for other jury selections, there's probably about 4 people who don't raise their card. But I can say this, I've had a traffic ticket before. It was probably when I was 19 or 2021, which was about 2 years ago. So anyway, that time when I got that traffic ticket, that was when the officers would pull you over and they would have a piece of paper and it would be carbon paper and they would give you their copy. And on that copy, it would tell you what they're accused of you of doing. For example, if it's running a stop sign or not wearing your seatbelt. So for this hypothetical, we're going to assume that an officer has pulled you over and the officer gives you a ticket and the officer says on the ticket that you ran a stop sign. Now, when you get that ticket, on that ticket, it'll say the date and time. It'll tell you what you're being accused of. I think they have a box that they check, ran stop sign or whatever. And it will tell you where you need to appear. Usually it's downtown at municipal court. So when you get that ticket, if you decide to go to municipal court and go to jury trial, that ticket doesn't mean that you're guilty of running a stop sign. You're accepting that ticket doesn't mean that you're saying, oh yeah, I'm guilty. It's just a piece of paper to let you know what you're being accused of. Does everyone understand?
Yeah.
Because how would it be if somebody said, hey, you need to appear in court for trial, and you show up and somebody says, surprise, you're here for a burglary of a vehicle, or surprise, not for running a stop sign, we have you here for not wearing a seatbelt. So those documents are just pieces of paper to give information to the person who's accused. Does everyone understand?
Yes.
It is not evidence of guilt, and it cannot be considered in any manner, shape, or form. Does everyone understand?
Yes.
All right, so Mr. Cespedes is here under indictment. Is there anyone here who's going to hold that against him or consider that in any way? If you are, raise your card. All right, the next thing I want to talk to you is about the right to remain silent. If you've watched, I don't know, Perry Mason, Paper Chase, The Practice, people have heard of the right to remain silent. What does that mean? That means if you're charged with a criminal offense, the state can't call you to testify. I've been a defense attorney. I've been a prosecutor. When I would have clients, sometimes I would tell them, you're just talking to me in the office and you're nervous and you're not even looking me in the eye and you're sweating. A jury's going to think you did it just because of the way you're presenting right now. And sometimes they would say, you know what, you're right, please, I don't want to testify. Or sometimes you have clients who have speech impediments, or some people are just shy. Or sometimes I would have clients, I would tell them, state didn't prove their case. There's no need for you to tell, your side of the story because they didn't prove anything. But the key thing about the right to remain silent is that anyone who's accused of a criminal offense does not have to testify at all, and nobody can call them to testify if they choose not to testify. Does everyone understand? Now, this part, when I would talk to jurors as a defense attorney or prosecutor, sometimes jurors would say, well, if that were me, I would want to get up and tell my story. And I would always tell jurors, but you know what? It's not you. And it's easy for you to say that because it's not you. And sometimes you may have attorneys who are giving you different advice because you want advice from your counsel. Just like sometimes you want advice from your doctor. How do I treat this? What do I do? Give me your advice. And then you can follow it or not follow it. So the key thing is the Constitution guarantees you a right not to testify if you choose not to. Is there anyone who's going to hold it against Mr. Cepedez if he decides not to testify? Now, the next thing I want to talk to you is presumption of innocence. Everyone who is charged with a criminal offense is presumed innocent. What does that mean? That means that unless and until the state proves their case, each and every element beyond a reasonable doubt, a defendant's presumption of innocence is enough to acquit them or find them not guilty. So, with presumption of innocence, what that means is the state has to present evidence that someone committed an offense beyond a reasonable doubt. Does everyone understand? So, if you had to vote right now on whether Mr. Cepedez is guilty or not guilty, what should your vote be?
Not guilty.
All right, so there's a lot of whispers going on. So if you had to vote right now, what should your verdict be in this case at this point in time, right now? All right, now burden of proof. What is the burden of proof in criminal cases? In all criminal cases, the burden of proof is proof beyond a reasonable doubt. What is the definition? That's what people always want to know. When I was in law school, you had to know the definition. I knew that definition forwards and backwards. I knew where to pause for the commas. I knew where to put the exclamation points. I also knew where to pause for dramatic effect. Then after I had my first jury trial, guess what? There's no longer a definition for proof beyond a reasonable doubt. So no one can tell you what proof beyond a reasonable doubt means because we don't have a definition for it. So the way I would explain it to jurors is by explaining it to them what it is not. Next door, we have the historic courthouse. The historic courthouse is that courthouse next door that has the green rooftop. They try civil cases. They have burdens of proof over there. One, when it's involving money, their burden of proof is usually preponderance of the evidence. More likely than not, something occurred. If you are ever on a criminal case, be it in district court where you are now, or misdemeanor court, and you are deliberating and someone in the back starts saying, well, I believe this happened more likely than not, you need to quickly speak up and say, excuse me, you're at the historic courthouse. You need to come back over here on the criminal side because that's not the burden. The other burden that they have over there, which is the highest burden, is clear and convincing evidence. Clear and convincing evidence is the type of evidence that is used to terminate your parental rights. So that means that the government comes in and says, you're a danger to your child. We're no longer going to allow you to parent this child, and we're going to remove you as their parent, their legal parent. Does everyone understand?
Yes.
Now, there's a burden that's higher than that. And the burden that's higher than that is proof beyond a reasonable doubt. That's the highest burden we have. The state has the burden in criminal cases to prove their case beyond a reasonable doubt. Defense doesn't have to do anything. In law school, this is the way professors would explain it to us. If you're representing someone, you can sit there, play video games, watch movies, hopefully with headphones so nobody else can hear. You can do crossword puzzles. And the reason why our professors would tell us that is to stress to us that the defense does not have to prove anything. They don't have to bring any evidence. The reason why is because it is the state's burden to prove its case. Each and every element. For example, all cases, criminal cases that are tried in Bexar County, the state has to prove that there's an incident that happened in Bexar County. If they do not prove beyond a reasonable doubt that something happened in Bear County, then they fail at their case. Does everyone understand?
Yes.
It's the same thing about on or about when something happened. They have to prove the date on or about. Does everyone understand?
Yes.
They have to prove the who. All right? The only thing they don't have to prove is motive. Does everyone understand?
Yes.
All right. Now, there are two phases of every criminal trial here in Texas. First phase, people call it the innocence phase, but that's not really what the first phase is. First phase is really, did the state prove its case or did they not prove its case? If they did not prove their case, then the verdict should be what? All right, y'all responding slow. We're gonna try that again. If they did not prove their case, what should the verdict be? All right, then if it's not guilty, the end, period. Now, if they did prove their case beyond a reasonable doubt, it goes to the second phase, and that second phase is what is called the punishments phase. In Texas, everyone who's charged with a criminal offense must make a decision, make an election, make a selection on if they were found guilty, who would be in charge of the punishment, who would render punishment. So people who are accused, they have a choice. They can say, hey, if I'm found guilty, I want the jury to render punishment. Or they can say, if I'm found guilty, I want the court to render punishment, which would be the judge. In this case, Mr. Cepedes has decided that if he were to be found guilty, he wants the jury to determine his punishment. And that's if he's found guilty. Does everyone understand?
Yes.
Is there anyone who's going to hold it against him because he's made an election to go to the jury if he's found guilty?
No.
Is there anyone here for any reason who cannot sit in judgment of anyone?
No.
Wait, what? Oh, somebody's like, what?
Yeah.
Okay, all right, sometimes people say, for religious reason, I can't judge anyone. Sometimes people will say, well, I can, but I don't want to do it because it's going to be too hard. Life is hard. Cases are hard. So the question is not whether it's hard for you or if it's going to be hard. The question is, if you were on a jury, would you be able to consider punishment? Is there someone here who's going to say, no, for some reason, I don't, for some religious reason or some deep-seated belief, I cannot sit in judgment of others. Is there anyone who feels that way?
No.
If you do, raise your card. And when I come back to you, I'm going to ask what Bible verse you're making that on. Okay, raise your card for me, please. 22, 28, 27, 33, and 39. All right, juror number 22. Don't fail me. Don't fail me now.
Sorry.
Thank you, juror number 23. All right, is there a religious reason?
Yes, my religious reason is the church I attend. The beliefs that I believe in the judgment, it is not my job.
All right, thank you. Number 28. Yes.
I feel the same way due to my religious belief. I feel that there's only one judge, and I don't want that on myself.
All right, thank you. And everyone, please remember to keep your voice up because the court reporter has to hear. Number 27.
Yes, ma'am. Same reason. I believe God is the only one who can make the judgment.
All right, thank you. 33.
Yes, I feel that my conscience, I would have a guilty conscience judging for someone who I have no facts. For the reason that they're.
And you say because you have no facts?
Well, I mean, it just bothers my conscience to make a decision that I know, that I don't feel, that I don't feel good about judging.
All right, thank you. Number 39.
Kind of same as the first juror. Only God could judge me, so I don't feel comfortable judging anyone.
I'm sorry, so you're whispering and the court
sorry.
reporter needs to
No,
hear.
I said only God could judge me, so I don't feel like I should be able to judge anyone else either.
All right, thank you. All right, the next thing I want to talk to you is about fairness and what fairness means. These are hypotheticals I've seen people use. People say, oh, let's assume that you're called up for jury duty. You know you're going to have jury duty today. So this morning, when you get up, you've already made plans on what route you're going to take. You're like, I know construction is here, so I know where to go. So what you do is when you get up that extra hour early because you want to be early. And when you come downstairs, your vehicle is on cinder blocks. Somebody has taken your tires, they just completely destroyed your vehicle. But because you want to do your civic duty, you're like, you know what, this is not going to ruin my day. And you still get an Uber or take the Via, or have your neighbor bring you down to court. You come down to court, you joyously wait. With great joy, you wait for it to be called up for jury duty. And you get to court, and when you get to court, you discover that the trial that you're going to be sitting on is a burglary of a vehicle. Usually people will turn to you and say, so you can't be fair, right? Because this is a burglary of a vehicle. When really, that's not the appropriate question. The question really is, your car has been burglarized. You just discovered that the trial you may sit on is someone who's accused of burglary of a vehicle. Are you going to say, you know what, my car was burglarized. I don't think this person did it. I don't even know if they did it. I don't care. I'm just here to find them guilty because they've been charged with burglary of a vehicle. Does everyone understand?
Yes.
So everyone always has their own trauma or things that have happened to them. For example, how many people here were born yesterday? Raise your card. And if you were born yesterday, how many people slept all last night? So I give that example to tell you, everybody has had things that have impacted their life. But the question really becomes, and what fairness really is, if you're selected to be on a jury, will you be able to listen to the evidence that's presented to you and base a decision, if you can come to a decision based upon the evidence that's presented? Does everyone understand?
Yes.
That is what fairness is. Is there anyone here who cannot give Mr. Cepeda or the state or the defense a fair trial or be fair in this case? All right, now the next thing I want to talk to you about is range of punishment. I told you the charge was aggravated kidnapping. So the range of punishment in this type of case is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Now, so what does that mean? That means that you could potentially sentence someone anywhere from 5, 6, 7, 8, 9, 10, all the way up to 99 years of life. Does everyone understand?
Yes.
Now, I need you to internalize that that's the range of punishment. And then if you were to find somebody guilty, whatever evidence is presented to you, you listen to that evidence, and then perhaps, you consider that evidence and base your punishment, if you're able to come to a punishment agreement, on the evidence that you hear. Does everyone understand?
Yes.
So you just have to be able to consider the entire range of punishment. For example, sometimes when someone is charged with murder, I'm going to use that as a hypothetical. Someone is charged with murder, and there was a time when I first started practicing, you could actually get probation for murder. But then they changed it. So now the range of punishment for murder is anywhere from 5 to 99 years or life in prison. And some jurors would say, oh no, I could never consider 5 years for a murder, or oh no, I can only consider life. So then I would always give them two hypotheticals. Here's the first hypothetical. There's a child that's born, great parents, great family, but he was always doing something. Started out stealing the next door neighbors' fruit from their trees, would destroy their daisies when they were in bloom, walk down the street, kick a dog for no reason, pull the wings off of butterflies, went to school, caused damage to the school, was always maybe graffitiing everything. And the teachers would always say, this child is going to end up being very dangerous to society. And then let's say that child grows up and that child just walking down the street, shoots someone and kills them. That's a murder, right? Now, let's say we have this other person, and the other person we have is this boy and this girl. Their parents, they were best friends, and they're like, hey, wouldn't it be nice if our kids fell in love and gave us grandchildren and we would always be together as a big, happy family? And so children start dating in high school. They get married. They've had their children, they've had grandchildren, and one of them gets very ill. They go see a doctor, and the doctor says, look, we can't help them. There's no cure for them, and they're going to die, and it's going to be very painful, extremely painful. So we just have some tablets. Here's some tablets for them to ease the pain. And that person tells their spouse, look, please help me. Let me just end this all right here and there. And that spouse helps them. Well, that's a murder. Now, in that case, maybe you say to yourself, that person shouldn't get life in prison. That person maybe should get 5. Or if there was probation for murder, maybe that person should get probation. So there are different factors that you can consider about ranges of punishment. So I give those 2 examples to show you when people say, oh, I could never do this or I could never do that. It really depends on what the facts are that you're hearing. Does everyone agree?
Yes.
So in this case, the range of punishment is anywhere from 5 to 99 years or life in prison. Is there anyone here who can't internalize that that's the range of punishment? And if you were to find somebody guilty, that you were to assess whatever facts are presented to you in giving punishment if you can give the punishment. Is there anyone here who cannot consider the full range of punishment? All right, the next thing I want to talk to you about is languages. As I told you, I love languages. Is there anyone here, raise your card if English is not your first language? 1, 3, 11, 20, 35, 36, 43, 52, 57, and 61. All right, juror number 1, what is your first language?
Spanish.
All right, have you been able to understand everything?
Yes.
Juror number 3, what is your first language?
Spanish.
Have you been able to understand everything?
Yes.
Juror number 8, what is your first language?
French.
Oh my gosh. Come on, Telly-Boo. So have you been able to understand everything? Yes. You know, you're the first person who's been on the jury and French is their first language. Oh, we'll have to talk how you ended up in Texas. All right. Juror number 11.
Yes.
Have you been able to understand everything? 20.
Spanish.
Have you been able to understand everything?
Yes.
Juror number 35.
Spanish.
Have you been able to understand everything?
Yes.
Oh, you guys are failing me. Juror number, we're gonna pretend that didn't happen. Juror number 36.
Spanish.
Have you been able to understand everything? Thank you. Number 43.
Spanish.
Have you been able to understand everything?
Yes.
Right. Number 52.
Fine.
Have you been able to understand everything? 57. Yes.
Spanish,
Have you been able to understand everything?
some,
All right. When you say some, what do you mean?
well, when I speak, it's some words I understand and some I don't.
Okay. Is it just the legal terminology or?
Yeah,
All right. Thank you. Number 61.
Spanish.
Have you been able to understand everything?
Yes.
All right. Thank you. Now, the next thing I'm going to talk to you about is time constraints, travel arrangements. I expect this trial probably to be concluded no later than Monday. Oh, somebody's like, what? So, is there anyone who has any type of time constraints? Please raise your card. All right, 2, 15, 17, 19, 21. And when I call your number, if you'll lower your card, please. 28, 33, 39, 36, 40, 49, 50, 57, 59, 60, and 63. Oh, and number 8. All right, number 2, what's your time constraint?
I have a daughter that's involved in school right now, school summer activities, and I have a trip coming up this weekend,
Where are you going?
Mexico.
Where,
Go give out school supplies to kids in a neighborhood over there this week.
and when is that?
We're leaving Saturday, coming back on Tuesday.
All right, thank you.
Yes.
Number 8.
I have a medical procedure on Monday.
All right, thank you.
You're welcome.
15.
I have therapy tomorrow.
All right, 17.
I'm currently enrolled into college, my summer classes,
All right, is it by Zoom or in person?
in person.
Did you let them know downstairs that it was in person?
Yes, they said if it's not today, then.
All right, number 19.
Medical appointment Friday
All right, thank you.
and
21
Monday. And Monday.
and Monday. All right, thank you for letting us know. 21.
I don't know if this qualifies, but I keep my 7-month-old grandson for my daughter and son-in-law 3 days a week. Monday, Wednesday, and Friday.
In Texas, where 7-month-olds are not driving and. All right, 28.
My oldest son will be sworn into the Air Force on Friday, and I would really like to be there.
Thank you. Congratulations. 33.
I have 2 doctor's appointments and I work out of town
All right, the doctor's appointments, when are they?
Monday.
All right, thank you. 36.
I have a job interview tomorrow.
All right, thank you. 39.
I leave Thursday for Mississippi for a family reunion.
But do you really want to be there?
I'm my first one going with this family. I just met this side.
All right, so is that good to be the first time going with that family? And the way you said it, going with that family?
I just met my dad, so yeah, first time with my dad.
Well, it's not a family reunion unless you play the song Family Reunion. All right, number 40.
I have a doctor's appointment tomorrow morning.
All right, thank you. 49.
I'm waiting for orders for deployment for a national fire assignment, and I have a medical appointment that I need to get done before I go on fire assignment.
Thank you. 50.
Well, thinking about it now is that, you know, I have a job, but the thing is, I do have, there's a specific code of leave I can use if I wanted to continue doing this with the court.
All right, thank you. Number 57.
I have a doctor's appointment tomorrow.
Thank you. Now 58 is like nothing happened to anyone else when they said something. Let me say something. Okay,
Yeah, I just remembered. I have an expo this weekend and a family birthday on.
I'm sorry, what's the first name?
It's an expo. I already paid in advance and everything. That's on Saturday, and then I have a birthday Saturday as well.
All right, so we're not gonna have court on Saturday.
Oh, my bad. Okay, the right.
59.
I respectfully withdraw. I don't think my reason is valid. It's work related.
All right, thank you. Number 60.
I have 2 things. One, I don't know if you were gonna go over this, but my daughter wears an ankle monitor. So I'm involved in a criminal case, so I don't feel comfortable being here. The other is I have a funeral to attend on Friday.
All right, thank you. 63.
I have a day appointment Monday morning.
All right, thank you. All right, so ladies and gentlemen, I'm gonna tell you, 17.
I apologize. I realize I do not have class this week. However, my birthday is on Friday, and I would like to spend time for me. But like,
Here's the thing, with birthdays, you should celebrate the entire month. So you don't just have Friday, you know, the whole month. I always tell people at least for a month. When your parents brought you home from the hospital, every little thing you did, they found fascinating, so you deserve to celebrate the whole. All right, I'm gonna tell you two stories. Both of them are very true. So I'm going to tell you two stories. Both of them are true. The first story I'm going to tell you about is my uncle. And I always tell jurors this story because I always tell them jury service is an inconvenience. It is not a sacrifice. And I say it's an inconvenience because you're getting called up, you have to fight through traffic, and now you have to fight through constructions. Then I see all of you all rushing to be here at 8 a.m. I see you, I tell you to slow down because it's really hurry up and wait, because I know that every court has a docket in the morning. So, and you have to pay for parking. And you're probably thinking, why do we have to pay for parking? We're coming down here to help you out. But it's an inconvenience. This is what I always tell people is a sacrifice. My family grew up in a small town called Grand Cane, Louisiana. And so my uncle was super smart. So when he went to school, his teachers would pass him to the next grade. They would tell my grandmother, they'd say, Miss Lane, we have taught him all we can teach him. And of course, when his sisters and his brother came behind him, it wasn't great for them because the teachers would say, we're expecting a lot out of you because, hey, your brother, he's a stellar performer, right? And he graduates from school. And then there's this conflict that breaks out. You may have heard of it, called the Vietnam War. And he comes to my grandmother and he says, because of civil rights and everything that's going on, there's no way for me to improve my lot in life here. And my grandmother had to sign for her firstborn to go to a place that nobody had ever heard of. And my grandmother, she had a 6th grade education, but she was super intelligent. She babysat me. I knew how to read and write and tell time, answer the phone, tell salespeople who are coming to the door to sell insurance, we don't want any, thank you so much for stopping by. So when she sent him off, and I know parents will say, oh no, we love all our children equally, but there's something about the firstborn because that's the child you're practicing on. And so when she sent him off, you mailed letters. She had his name, she had his number, and you would wait to receive a letter back. When my grandmother grew up, and when my uncle was growing up, they finally got a television set, 3 stations, ABC, CBS, and NBC. And NBC, you really couldn't count on because if there's a breeze and the weather's not right, you're not going to get anything. No matter how you turn the mouse ears or whatever, or put aluminum foil at the top, just not going to happen. And then you didn't have 24/7, all of this 24/7 TV programming. You didn't have that back then. At some point, the programming ended. You knew it ended because either your TV would just have the white noise or either they play the national anthem. And after they played the national anthem, you just see a flag blowing in the breeze. But of course, you turned the television set off because you didn't want the power to mess up with the TV. My grandmother did have a phone. It wasn't a touch tone. It wasn't a rotary, which I know young people don't know what that is. Her phone had no numbers. So what would happen is you pick up the receiver, an operator would answer, and you would tell them who you would want to call. That's why they would have songs like Beechwood 45789. So my grandmother sends him off and just waiting to receive a letter back that he arrived safely. She received the letter back. My grandmother quickly realized that the one thing you do not want happening is you do not want people in military dress knocking on your door because that was bad news. So I would always leave that story right there. But then the Deputy Laura would tell me, Judge, what happened? You can't leave people wondering what happened. Did he make it back? My uncle did make it back. My uncle has since passed. Some of his siblings have since passed, and my grandmother has passed. But I tell that story to people because your country only asks 2 things out of you, really. They ask for you to pay your taxes and show up for jury duty once in a blue moon. There is no drafting. They don't have any of that. Just two things. And I always see people, Memorial's Day, Veterans Day, the 4th, everybody wants to wave flags and say, I'm for the troops. And I always tell people, you really want to be for the troops? Start by helping your government. Only two things they're asking for you. Serve on a jury once in a blue moon and pay your taxes. So raise your card if you have ever served on a jury and listened to testimony. And that's usually what ends up happening. And I'm sorry, could you turn your number around, sir? What's your number? Number 27. You've served on a jury before?
Yes,
Oh, stand please. And you've heard testimony?
I heard.
Yes.
Yes, ma'am.
And did y'all reach a decision?
Yeah, they kind of wasn't it like well they decided there wasn't enough
Evidence. Okay. All right. Thank you. All right, everyone, you can lower your cards. And that's why I bring that up. So you can see your government is not even asking you to come down and serve on a jury once every 3 months. It's like once in a blue mail, you get that card in the mail. I think they do it electronically now. The other story I want to tell you is about my friend from law school. She got called up for jury duty. And when she got called up, she said, hey, let's do lunch. She does civil work. I always wanted to do criminal. So we have lunch. I asked her how it's going. She's like, it's going fantastic. And I'm like, how can it be going fantastic? And so she tells me, I'm not going to be selected. She said, it's just like when I was in law school, I'm on the back row. I'm not raising my hand. I'm not answering anything. I start laughing. She say, what's so funny? I'm like, I'm happy because we're going to be able to have lunch all week because you're going to be on this jury. So other than raising your hand and saying, please place me on this panel, the quickest way to be on this panel is if you are silent. Each side is going to have 20 minutes to talk to you. They don't get a chance to come to your house, to have dinner with you. They only have 20 minutes. So they're trying to learn as much about you as possible. So with that, I'm going to turn it over to the state.
Yes. Good afternoon. Okay, I'll take it. I'll take
Yeah.
it. It's almost 4. So as the judge said, we are here for an aggravated kidnapping case. But here are some of the goals for jury selection. As the judge said, we're here to talk to you. We want to know your thoughts, your feelings, whether you agree or disagree with certain laws. And let me just be upfront with you, that's totally fine if you do, okay? We just need to know so that we can take that into consideration, all right? And the ultimate goal is to find 12 fair and impartial jurors who are right for this case. And Judge used a burglary of a vehicle example earlier. Who here knows about or of Willie Nelson? Right, most everybody, right? Juror number 68, what's he famous for? Oh, singing, sure. There was a gentleman back there in the blue hoodie. What's your number? 70, what's he famous for? Singing, okay, 66. Thank you. Okay, everyone knows Willie Nelson.
Yeah.
Smokes marijuana, right? If we were here on the possession of marijuana case, you think he'd be a good juror? No, probably not, right? And that's what we mean, okay? He doesn't agree with the marijuana law, and he's not afraid to tell you about it. We just need to know, okay? All right, so as the judge said, burden of proof is proof beyond a reasonable doubt. That is the standard that we hold here in our district courts and county courts on the criminal side. There is no definition, so we can't help you there. It's up to each individual juror to come to that definition by yourself. But I can tell you what it's not. It's not proof beyond all doubt. It's not 100%. And there's a very, good reason for that. If you knew something happened 100%, how would you know that? What was your number? Your number 15?
You'd have to have actually witnessed it occur.
Okay, and if you witnessed it occur, do you think you'd be in the jury or up on the witness stand?
Probably up on the witness stand.
Okay, and so does everyone understand why we can't show you something 100%, right? Is there anyone who would hold the jury to that standard of saying, no, I need you to show me 100% beyond all doubt that something happened? Nobody? Okay. All right, so aggravated kidnapping, I'm gonna be upfront with you. It is a very detailed statute. But it is intentionally or knowingly abducting a person with the intent to inflict bodily injury, to violate or sexually abuse, or to terrorize the complainant. And you abduct them by restricting their movements without their consent, so as you interfere substantially with their liberty by either confining them in a place where they're not likely to be found, or you're moving them from one place to another in a place and holding them in a place they're not likely to be found. Okay, that's very convoluted. But basically, you are taking somebody without their consent, right? And you are either holding them someplace they don't want to be, or you're moving them from places they don't want to go. And you're doing that, and you're going to assault them, or sexually assault them, or just generally terrorize them. Okay. The other way you can commit aggravated kidnapping is you do all that, you abduct the complainant, okay, and you restrict their movements by either holding them someplace they don't want to be or moving them someplace they don't want to go. And you do that with a deadly weapon. Okay. Are there any questions about that statute?
No.
No. Okay. And so let's talk about some of the words that are used in there. Intentionally, right? That is a conscious objective or desire to engage in conduct or cause a result. Basically, did you mean to do that? Okay, so if Rick and I are arguing, right? And I walk up and I punch him, can everyone agree that I probably meant to do that?
Yeah.
Okay, sure, number 7, what would tell you that I meant to do that? I hit him. Okay. Right, so you can infer intent from your actions, from the context, from my words, right? Knowingly, you're aware of the nature of your conduct or that circumstances exist. Basically, did I know what I was doing when I did it? Okay, so maybe instead of just walking up and straight punching Rick, I'm like, oh, I don't see you, but I know you're there, right? I know that he's in that vicinity. I know that I'm gonna hit him. Did I intend to? Did I walk up and look him in the face and hit him? No, but I knew he was there and I knew it would happen. Does that make sense to everybody?
Yes.
As I said, you're not required to read anyone's mind. You can infer intent from actions, from words that are used. And those are things that you may or may not hear in the trial, right? Help you come to your conclusion. So abduct, and we kind of already went over this. This is where you restrain a person with intent to prevent liberation. Basically, I am confining you, right? I'm keeping you in a place you don't want to be kept or moving you to a place that you don't want to be without your consent, okay? So let's talk about a deadly weapon. Anything that is manifestly designed, made, or adapted for the purpose of inflicting death or serious bodily injury, or anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. So if I say deadly weapon to you, juror number 28, what do you think?
Gun.
A gun, okay, anybody else? Juror number 26,
Knife.
a knife. Anybody else over here? Juror number 23,
A bat.
a bat could be, right, if it's in the manner of its use, right? Juror number 10. His fist. Your fists, right, in the manner of its use, right, depending on how you use them. So I think you pretty much got everybody. A car, right? A car could also be used as a deadly weapon. All right, so let's go ahead and talk about the type of evidence that you might expect in any sort of criminal case. What might you expect? I'll leave it open. Just raise your card. Juror number 35?
Pictures.
Pictures, okay. Anybody else?
Testimony.
Juror number 21, testimony. I'm gonna touch on that. How much do you think testimony plays in any case, really?
I think it depends on the witness.
Okay, so right, it's your duty to judge the witness based on what they say. But testimony is what you're gonna hear from the witness stand, okay? And some cases may have things like pictures, may have things like body cams or what have you, but most of what you're gonna hear is gonna come from the witness stand, from people testifying, okay? And one point that I do want to explain to everybody is that you can only consider the evidence that's admitted at trial. So a lot of times when witnesses come up to testify, we may show them things like their report, you know, to help refresh their memory. They may say that they gave a prior statement, but those things are not going to be admissible at trial typically, okay? What you need to do is listen to the words that they are saying. And when you go back to deliberate, you can only consider the things that go back there with you. A lot of things like those reports or prior statements aren't going to be back there with you. That's why it's important to listen to what witnesses say. Can everyone agree to do that for me?
Yeah.
Quick point. We are not, as much as I would love to be, I am not Law and Order. I'm not cold case or NCIS, Criminal Minds I watch all the time. I wish every case could be boiled down to a piece of hair or solved and convicted or not convicted within an hour, okay? It just doesn't happen in today's world. And in fact, a lot of the investigations may not be what you see on TV, okay? Because it's TV, right? So speaking of police investigations, I do want to talk about some things that may impede a police investigation. What are things that make those investigations harder? Number 15?
Evidence tampering.
Sure, evidence tampering. What about any language barriers? Do you think that would make an investigation harder?
Yes, it would.
Juror number, who said that? Juror number 1, why do you think that would make it harder?
Because sometimes when the different languages that we speak, when you speak Spanish and you speak English, they can get interpreted incorrect.
So if you speak Spanish or English, it could get interpreted incorrectly?
Or
Translated incorrectly. Okay. And so you may say one thing and they take it as something else.
Right.
Okay, and could that happen even if both people are speaking Spanish?
Yeah, sometimes because the terminology is different, depending what type of Spanish you speak, there's different language in Spanish to speak.
Okay, and juror number 3, you're nodding. Thank you, jury number 1. Juror number 3, you're nodding your head. Do you have anything to add?
No, I think the same thing as her. Like, I'm from Puerto Rico, my Spanish, my words are different than, let's say, someone it's from Mexico, and sometimes they can be translated differently.
Okay, all right, well, thank you very much. All right. So, as juror number 21 was saying, testimony is evidence. So you're going to hear from witnesses. Some witnesses you may or may not hear from would include police officers, any civilians that were there. As the judge said, you may not hear from the defendant. There may or may not be defense witnesses. They don't have to do anything in this trial. We hold the burden, okay? But you are the exclusive judges of the facts that are proven, the credibility of the witnesses, and the weight given to the testimony. And that's what I meant earlier by just listen to what they say. You get to judge however they testify, however you want, and give it as much weight as you want. Some things that you may want to consider is the witness's demeanor. What they say, does it actually make sense? Do they have any motives to lie? What about their ability to recall details? Is there corroboration from other testimony? Is there corroboration from other evidence? Right? These are things that you can think of when determining the credibility of witnesses. As the judge said, there's a right for the defendant not to testify, and you can't use it against him because that wouldn't be fair, right? For a country to say, we give you this right and then we're going to hold it against you if you use it. Does everyone agree that would not be fair?
Yes.
Okay. Defendant has other rights, the right to remain silent, the right to a jury trial, presumption of innocence, the right to or not to testify, to see all of our evidence ahead of time, to watch and listen and read all statements. They get copies of all police reports. They can, if they choose to, subpoena any and all witnesses they want, and they get to question the witnesses if they want, okay? The judge did already talk to you about punishment. One thing I do want to talk to you about is a certain mitigation factor if it's shown at trial that the defendant, after taking or holding that person in a place they don't want to be held, later releases them to a safe place and they show that to you by preponderance of the evidence, which is more likely than not, then the punishment range changes from 5 to 99 to 2 to 20. Okay? But as the judge asked you earlier, can everyone still go over the entire punishment range if we get to a guilty verdict?
Yes.
Yes. Okay. And then probation is an option. All right, so let's talk a little bit about family violence.
Sorry, it was an alarm.
All right, can anyone tell me why it's important to prosecute family violence cases? Oh, juror number 6, 9.
The safety of the family.
The safety of the family. Okay, anybody else? Juror number 22?
Oh, no, sorry.
Just kidding. Can you put those up again? Juror number 67?
It can be repetitive.
It can be repetitive. What do you mean?
Well, don't know that you've done wrong. You know, nobody calls you on it. You don't know that you've done wrong.
If nobody calls you on it, you don't know that you've done wrong. Okay?
Somebody got to.
Yes, sir. 21?
Because it can escalate.
Okay, what do you mean?
For the same, I think, building on what this gentleman just said, I mean, and because of my career, I've seen it happen where a person in a relationship, you know, is abused, and then it keeps getting worse and worse.
Okay, thank you very much. Anybody else want to speak on that? Juror number 49, I saw yours first.
I mean, somebody can end up dead.
Somebody ended up.
Child, woman,
I'm sorry, could you
Can
stand?
you stand up for us? Can you repeat that and stand up? I apologize.
Somebody can end up dead. It can be a fatality.
Okay, thank you very much. Juror number 41. You can stand as well.
It needs to be prosecuted because these abusers can still live out freely in the world and continue to abuse and get to live their lives openly.
All right.
All right, do you have a number behind you?
Oh, I'm sorry, juror number 1.
Sometimes it could be something that it's a pattern that's gone on for generations.
A pattern that's gone on for generations. Okay, thank you very much. Just because we are short on time, I am going to move on. Who here's heard of the cycle of violence? Juror number 38, what is that?
So essentially, the cycle of violence, I guess with domestic violence, a lot will happen. With the abuser, abusing somebody and then taking them back, and then it just like repeats itself, right? Where the victim will forgive them, and then again building on the repetitiveness of an escalation of domestic violence. So it usually gets worse and worse.
Can you say that just a little bit louder?
Oh, so the cycle is as far as the victim taking the person back, the abuser back, and then it escalating based on what they were saying as far as the repetitiveness, escalates and gets worse and worse. All right.
Thank you
5
very
minutes.
much. Thank you, guys. All right. And so why do some people stay in these types of relationships that we're discussing? Juror number 41.
They fear for their lives and the lives of their loved ones.
Okay, juror number 58.
It could be for financial reasons.
Financial reasons. Okay, juror number 20.
I think sometimes they can get isolated, so then it just feels like there's nowhere else to go. So then they just stay.
Okay. And anybody else wanted to, juror number 75, I'm sorry.
Lack of self-confidence.
And I think for the court reporter, you said lack of self-confidence, lack of self-love, and not knowing they deserve better.
Yeah.
Okay. Ashley. Juror number 8.
Kind of the same as what he said, is they think they are guilty. They caused it.
And I think that pretty much gets everything on my little list here. Now, what happens when somebody breaks that cycle? Anybody? Juror number 9?
They gain their life back.
They gain their life back. Okay. Juror number 1?
They get more confidence, they have more depth of life, what they look forward to.
Have more confidence. Okay, juror number 10?
They live in fear, but they're glad they're grateful that it's life. Where they just have to depend on themselves and take care of themselves and their children.
And so I know we've got a lot, I appreciate all your answers, but I do have to move on. So Do victims in family violence cases always want to proceed with cases?
No.
Okay. Why might they want to proceed after they're out of this cycle?
So
No, Jennifer, I'm sorry, let me get number 12.
so that, you know, if they are a parent that they can, an example for their kids, for them, for that, happen to that.
All right. So let me ask, so which goal should be more important in our criminal justice center? Either one, to rehabilitate, prevent crime by focusing on the offender and trying to change them, or two, to punish, preventing crime through penalty or confinement. Now, I do have to ask you to pick one. I'm sorry, one or the other. So it can't waffle, right? And I do need a decision. Who here is a 2? That means that you think that the goal of our criminal justice system should be to punish, to prevent crime through confinement. And if you could just hold your cards up high, and then I will, as soon as I call your number, you can let them down. That's going to be jurors number 2, 3, 8, 9, 10, 12, 16, 23, 24, 25, 31, 35, 36, 38, 40, 41, 42, 43, 63, 64, 66, and 71. All right. So then, just so I understand, everybody else here is a 1 and thinks that the goal is to prevent crime by trying to rehabilitate the defendant or the criminal. Okay.
Yes.
Thank you. All right. Has anyone here or someone very close to them, like a sister, like super good best friend, been a victim of a violent crime? If so, raise your cards up. Okay, that's going to be jurors number 1, 3, and keep 1, 3, 9, 10, 11, 26, 24, 30, 39, 40, 41, 46, 57, 60, 63, 68, and 73. 26, did I call you? Okay. Now, out of those who raise their cards, who here, because of that prior experience, cannot be fair and impartial in this case? Raise your cards. Okay, that's going to be jurors number 3, 10, 40, 41, and 63. All right.
Fine.
All right. Thank you very much.
Okay. All right, defense.
All right, good afternoon. I've got some good news for you. Thankfully, Judge Boyd was so thorough with her questions and the state was very thorough with their questions. I really don't have a whole lot left to ask you guys, so this shouldn't take too long. First questions first. I don't recognize anyone here, but I can't see just about anyone. Does anybody know me or the prosecutors or my client? No?
No.
Is anybody here related to or know someone or are in law enforcement? Okay.
Or know someone, you said? Know
That's
someone?
correct.
Know what you said?
Correct. So we've got, same thing, if you just leave your cards until we call your numbers out. Juror number 1, 6, 7, 8, 9, 10, 12, thank you. 24, 25, 26, 27, 30, 31, 33, 34, 35, 36. Excuse me, 38, 39, 42, 43, 49, 53, 57, 59, 60, 61, Bexar, 63, 65, 68, 69, 73, 74, and 75. Okay, for everyone who answered that question, actually, I should say this is for everybody. Is there anybody here who would believe the testimony of a law enforcement official simply because they're in law enforcement? In other words, do you give their testimony greater weight just because they're a police officer? Okay, I've got a couple in there. Number 38, 31, 75, 50. Thank you. Anybody else? Comment? After hearing the state talk, asking their questions and explaining the charges, is there anybody here sitting now, after hearing everything that's been said, have you changed your mind and have an opinion about my client being guilty as he sits right here? We all agree, would everyone agree that my client still sits here not guilty?
Yeah.
Any disagreement? Has anybody here ever had a bad experience with law enforcement? I don't mean just I'm like, oh, he pulled me over and I got a ticket and I'm mad about that. That kind of makes everybody mad. But has anybody ever had a bad experience dealing with them? Number 39, number 63, number 34, number 43. Without going into details, because I understand, we're around a whole lot of people and you may not want to air certain things. Would that experience with law enforcement that you've had, that you considered, would that affect the way you would be able to sit and listen to the evidence and affect your judgment as a juror? Did I make sense? Did I kind of talk myself in a circle on that? Okay. I believe the judge talked about it a little bit, but let me go back into it again. We were talking about biases. Now, I believe we generally want people to remain unbiased. Would you agree with that?
Yes.
But everyone has their own formulations baked into their brain when they come in. Okay. I'll give you a great example. I have a very, very good friend of mine who moved to Texas from San Diego. And he moved up to the Dallas area. And when we would work together, he would say, the Mexican food in Texas sucks. Quote, plain quote. I'm not gonna, say one way or the other, but I think that's the example to use of him being so used to eating food in San Diego that when he experienced a different type here, it kind of affected his judgment. So along the same line, is there anybody here, as you sit here right now, you think, you know what, Don, I'm just not, I don't think I'm a good fit for this case. Is there anybody here who thinks they're not a good fit for this case? Okay. Number 3, number 40, 41, 31, 30, 12, 22, 40 and 41, I think I get 57, 60, 63. Anybody else? Number 10. And if I might ask if I could pick on a couple of y'all. Number 10, why would you say that you're not a good fit?
I've been through violence
Okay.
and it's a lot of mixed emotions.
Okay.
One of very
Understand.
angry,
I understand.
sad,
Okay.
fearful. Too many bad moments.
I understand. I thank you for your honesty. Would it be fair to say that you could be a fair juror?
Could not
Thank
say
you.
that could be, cannot be. I think a lot of it would come from what I experienced. And it would be the person. Because of my anger. I didn't.
Well, I appreciate your honesty. Thank you. I believe we had another one over there. Was it number 3? Why would you be a bad fit for this?
I was also a victim of violence. I was in a very abusive relationship, and I just don't think it would be fair for me to be judging him based off of that.
Thank you. Appreciate it. Is there anybody else who thinks they would not be fair? Number 30, I see. If you have your card up, number 30.
Yes. My youngest is level. I can soft spot for that.
If I just to make sure I heard you right.
He was almost abducted by a guy in the car. I called him over, offered him to. It was summer, they were playing. So he needed to retire, so he offered him a bill meter seat. And he almost went into the car. But a neighbor stopped.
Would it be fair to say that that experience would lead you to not be a fair juror in this matter?
I like to say I'll be fair, but I got a feeling toward. It'd have to be very, very good.
Thank you, sir. Is there somebody else I missed over here? Number 60? Why would you be unfair? Or do you think you would be fair in this case? Okay, may I ask why?
My sister was abducted. When she was 9 and I was 12, and then she was raped. So I don't know.
Okay, I appreciate it. Thank you, ma'am. Number 57, yes, ma'am.
I'm just saying like that, very, very. With some words I don't understand that. That's it.
Okay. Thank you, ma'am. Did I miss anybody else for that question? Number 40 and 41? If I could address you just one at a time, not both, but juror number 40, do you think you would be an unfair juror if you would stand up, please?
Well, it would depend if it was a child or a woman kidnapped. I'd automatically go to the guilty.
Okay. Thank you. And juror 41?
My daughter was raped by her biological father when she was 11. And nothing happened to him, so I don't think it would be fair.
Okay, thank you. I appreciate that. Number 66, yes, sir. I'm sorry, would you say that one more time?
I have a daughter. I something derogatory like that. I know it.
Okay, thank you, sir. Juror number 12, did I call on you? I did not. May I ask you why you think you're a bad person?
I do have a daughter, and it just, the thought of it is very, just, I'm not saying like, would I be hurtful? I don't know. I'm just saying that that is something that I put myself in that parents. You know, and just think on their shoes and just think, oh my gosh, you know. I can't.
Thank you, ma'am. And I'm just gonna do one more. Juror number 22.
I have similar feelings like the other two ladies. It's emotional. I myself been through something, and I don't think that I could do it either. I don't, and plus I can't judge them.
Thank you. Okay, moving on, the state mentioned something when they were going over terms of punishment. And they said probation is an option. Is there anybody here, if all of the elements are met where probation could be an option, is there anyone here who could not consider probation as an option of punishment? Okay. Got number, I'll get you 2, 3, 6, 10, 12, 17, 18, 19, 20, 21, 30, 35, 36, 38, 40, 41, 50, 66, 75. Thank you. I think the judge touched on it a little bit ago, talking about jurors in the panel. When we talk to you, how we like y'all to talk and give us, because it's our only shot. I'll give you a very great example of why I'm thankful for y'all talking, especially in this panel. I tried a federal case last week in Del Rio, and the first 8 people, numbers 1 through 8, said nothing. And 6 of those 8 made it onto our jury. So it really kind of helps you it helps you if you're trying to not serve, but it's the saying we always say, those who don't speak up usually get selected. So I do know we appreciate you. I know the state appreciates you, and I know the judge appreciates y'all being so forthcoming with us. Let me ask you one last question here, and this is my general catch-all question for everyone. As you sit there and you're listening to me talk, and you think in your mind, you say, you know, I wish he would have asked this one question of us. Is there anything going through your minds right now that you're like, you know what? You should know about this. Anybody have anything like that at all? Something we've missed that you think is important that we should know about? Anybody? I appreciate your time. Thank you very much.
All right, ladies and gentlemen, I'm gonna have you all step outside in the hallway. You're not excused, but leave your numbers behind and take your items with you, and we'll call you back in shortly.